Welcome. Welcome everyone out there in wonderful land. Welcome to the Law, Your Money and You. I'm Roberta Saphire, an attorney in Sharon, Massachusetts. And
Hi, and I'm Camille Barron. I'm a healthcare advisor and financial coordinator, also in Sharon, Massachusetts. And Roberta, today we're going to have a lovely conversation with someone who's going to talk with us about estate planning law.
yeah, and what's funny, talk about relatives. My son-in-law's sister's married to an attorney, Victor, in Phoenix. They've been out there for years. And that was one of my questions to our guest, Melissa Victor, who's been around a while, although she looks like 28. She's been practicing over 20 years in estate planning, and this topic always comes up. We must get 3 or 4 emails a day more on this topic than any other. Melissa, let's start by welcoming you and tell us a little bit about yourself.
Sure. Thank you so much for having me. Again, it's Melissa Victor, and my office is in Easton. I've been practicing estate planning and elder law for over 24 years. I grew up in New York and moved out here to go to law school, and I opened up my own practice in 2002. And I have only been doing estate planning and elder law. That is my specialty. And I've probably helped thousands of people put together an estate plan or deal with a loved one who's passed or unfortunately had to go into a nursing home.
Do you deal with all the probate courts in Massachusetts? Is there a few that you do more than others?
I probably deal mostly with, I would say, Bristol County, Norfolk County, and Plymouth County, just because my office is in Easton. But of course, we can do probates anywhere. It's relatively the same. You know, I've done a lot in Middlesex and Suffolk County, although those are the busiest courts right now and seem to take the most time. I try to stay mostly local, but you can certainly do probate in any county.
Yeah, they have uniform probate laws. Do they have them in all the counties?
Yes, so Massachusetts enacted the Massachusetts Uniform Probate Code. So everything is supposed to be the same in every county, although they can use a little bit of different forms in each county. That's why it's good to continue to practice in the same county, because you get to know the clerks and, you know, the specific forms that need to be used. But, you know, mostly throughout Massachusetts, it's very similar regardless of what county you're in.
Camille was mentioning to me Norfolk Probate. I don't know if they're still closed, but the register there, Pat McDermott, is now the sheriff. Have you noticed any changes? Yeah, he's a Norfolk County sheriff now.
He was the register of probate for a really, really long time.
18 years.
Actually, one of the things that COVID brought to the courts is the ability to do what they call a virtual registry. So before, if you had questions, you would have to call and hope to get through to somebody, or you would have to head down there and, you know, go talk to somebody at the desk. And now they offer a virtual registry where it's very similar to Zoom. You wait your turn and you get a person live and you can talk to them specifically about your case. And so I think it's really helped and saved a lot of time, at least for us attorneys, from having to travel to the specific court, especially if it's Middlesex or Suffolk and you're, you know, south or north of the city. It's definitely helped the situation.
Yeah,
well, speaking of COVID, it seems like there's a lot more awareness now of estate planning, if for nothing else, to have your living will and your advance directives in place, because if someone, either yourself or someone in your family, should get COVID, you know, do we want to preserve life and have people on a respirator for the rest of their lives? Is that something we can talk about?
For our help, Camille came up with a word, living will. Tell our viewers.
So living wills are actually not legally binding here in Massachusetts. They are a document that says if there's no reasonable expectation of your recovery, you know, you don't want to live in a vegetative state, you don't, you know, you only want comfort measures. I always have clients sign a living will if that's the way that they feel. But here in Massachusetts, it would be up to your healthcare agent, the person you've named in your healthcare directive or healthcare proxy, to ultimately make that decision. In some states, like Florida specifically, if you sign a living will, the doctor must follow that. But here in Massachusetts, there is no specific law like that. So ultimately, it is up to your person that you've named. But I always advise my clients, if they feel that way, to certainly put it in writing, because it will help families make a decision if they know what, your
Right.
wishes are.
And certainly avoid a lot of problems, conflict within the family if the proxy says this is what's going to happen.
Exactly.
If at least it's in writing, the other family members can't argue with that.
Right. And specifically, COVID has sort of brought a lot of things with estate planning and elder law to light. A lot of times people ask me, why people don't do estate planning. And a lot of times it's procrastination. They're afraid if they do estate planning that they're going to pass away, or they don't understand. There's so much information out there that it can be very confusing. I oftentimes equate estate planning to going to the gym. I always get anxiety when I go to the gym because there is a machine for everything, and you don't know what you should do. And just like if you got a personal trainer who went through your body style, your living style, they would come up with a plan for you. That's very similar to estate planning. What I might recommend for one family may not be what I recommend for another family, and it's all based on their particulars. One person might have a special needs child. There's a lot of things to take into consideration. So I always advise people not to always listen to everything that's out there, that it's informational only. And just like with a personal training plan, you need your own personal plan to fit your needs.
Is Rhode Island much different than us, would you know, or New Hampshire, the surrounding states?
I think everybody has similar rules. The probate court process might be different. It may be harder in those states or easier in those states, but every state does have their own different probate laws and estate tax laws. So I only deal with Massachusetts, and while I do get some clients that call because they live on the Mass-Rhode Island border, if they are in Rhode Island, they do need to deal with somebody in that state to get more specifics as to those state laws.
So tell us, what are some of the things that people need to know and understand, say for someone who's really not been actively involved in estate planning for themselves or their family?
So I think the biggest misconception out there is one that we get on TV, and that is you always hear about a will. And so everybody thinks that if they have a will, that they're covered for everything. And I always tell people that's just drama on TV when you see those will readings. Those don't normally happen in real life. But the very basic plan would be to have a will. The will is the document that says if you pass away, who's going to be your personal representative, executor, and where assets go. But I think what people don't realize, and the misconception, is that a will has to go through probate court. So if you have an asset in your name alone, even though your will might say, I leave everything to my daughter, it still has to go through the probate court to legally change title. The bank can't legally give the bank account to the daughter until such time as somebody's appointed the personal representative, and then legally they can transfer it. So I think a lot of times people think that if they have a will, they're all set. But realistically, the best form of estate plan would be to have some kind of trust. And that would help to avoid probate. If you think of a trust as a treasure chest, the idea is to have your assets in this trust name so that when something happens to you, none of it has to go through the probate court.
Mm-hmm. And there are two basic kinds of trust, right?
Correct. So there is a revocable trust. This is a trust where, if I was doing the trust, I would be what's called the creator or the trustor of the trust. I create the trust, and then I would also be the trustee. The trustee is just the person that controls and manages in the trust, for the beneficiary's benefit. So in a revocable trust, which is what I have, I would be the creator of the trust, the trustee, and it would be for my benefit, which essentially just means that even though my assets would be in the Victor Family Living Trust, I would still have complete access to those accounts. So revocable means that I could change it at any time if I want to change the beneficiaries. What revocable trusts do is they avoid probate, but they don't give you nursing home protection, which a lot of times my clients who are, maybe over 65 or older are always looking for a little nursing home protection to protect their assets. So that would bring us to the irrevocable trust. And when you create an irrevocable trust, you cannot be the trustee. So most of the time, my clients will name a child or children to be the trustee of the trust. For instance, if you conveyed your house to this irrevocable trust and your children, let's say, are the trustees, there's a 5-year look-back period before it's protected for nursing home purposes. And most people don't understand that 5-year look-back period. What it really means is, if you go into a nursing home today, you don't want to apply for Medicaid or Mass Health. It's the same term. It's just interchangeable. That's when you essentially can't pay for your own care. So if you apply for Medicaid, they will ask you, have you made any gifts in the past 5 years? I mean, essentially, they don't want you giving your assets away yesterday and then applying for benefits today and say you're poor. So the 5-year look-back period only comes in when you apply for Medicaid, and then they have the ability to look back for 5 years. So
I have a question on that point.
Go ahead.
This is just like, so here, let me give you the first question here. We had a couple, the fellow had long-term care. So I don't even think they need Medicaid. You might touch on that.
Sure.
He had long-term care, but he had a lot of assets. So they moved him out of one nursing home to another in New Hampshire because they said they would save on estate taxes and other benefits. I thought that was a good point to touch on.
So long-term care insurance is an insurance that is sold by an insurance company that provides coverage in the event you are in a nursing home. And just like any insurance, it's never really the full benefit. I mean, you have a deductible, and then you have certain coverage. So for instance, a long-term care insurance policy might cover $200 a day for 3 years that you're in a nursing home. So there's a pool of money. There are different types of policies you can buy. A lot of times, though, people don't have long-term care insurance. They think it's very expensive, which it can be. The best time to buy long-term care insurance really is when you're in your 50s, which most people don't want to think about a nursing home in their 50s. They're thinking about a retirement. But it is the cheapest time, certainly, to buy it. But it's never going to cover you in full. So, most nursing homes probably cost between $300 and $500 a day. This is a benefit that would give you, $200 or $250 a day, and then you'd be responsible for the rest.
What if you don't have the rest? Is that when Medicaid kicks in?
Yeah, so that's when Medicaid would kick in, and what would happen is long-term care insurance would pay, let's say, the first $200, and then Medicaid, could cover the rest. So it's very useful to have because it does help us as elder law attorneys, work to figure out whether it's pre-planning or emergency planning. I think the biggest myth out there is that you can't get Medicaid and still have assets, and that's not entirely correct. Obviously, it depends on whether you're married or, single, widowed, divorced at the time you go into a nursing home. But as a married couple, there are so many things that can be done, even if you haven't planned. A lot of times people don't know that, and so their loved one goes into a nursing home, and the nursing home might ask them about their assets and say, okay, you have to spend down your money until you're broke, and then we can get you on Medicaid. Ultimately, that's not necessarily the truth.
Well, they're not going to kick them out, are they? I mean, how can they kick them out?
They do. I mean, they try to. I mean,
I'm not leaving.
It's not hard.
I'm not going in there.
It's not what they always want to do, but they certainly threaten that. I always tell people, if your loved one is going to go into a nursing home, you have nothing to lose by speaking to an attorney. I mean, nursing homes are great, and I've worked with many that have told clients to go see an attorney, and I've worked with many that have just said you have to spend down your money. But there is no harm in speaking to an elder law attorney because a lot of times I can save people hundreds of thousands of dollars.
What do you think about this New Hampshire thing? Have you ever heard of one like that
Oh, where they moved them to the other nursing home
in New Hampshire?
and it was private pay?
Yeah, I don't know, they figured they would save on estate taxes unless I
Well,
got it
it-
wrong. Seems
Well,
drastic.
so it could be. So I don't know if there's estate taxes in New Hampshire. Here in Massachusetts, if you die with over $1 million in Massachusetts, there is a potential estate tax that needs to be paid. If you're married and you plan properly using a revocable trust, you can pass 2 million, one for each spouse, but you have to plan properly to do that. Otherwise, you just get the $1 million.
It's
Sometimes
interesting.
people move to Florida because there's no estate tax in Florida.
You were speaking about Medicaid and long-term care. I'm in the insurance business myself
Right.
and deal with a lot of people on Medicare. It's surprising how many people think that Medicare will cover your long-term care, nursing home, or assisted living costs, and that's just not
Correct.
true.
Correct.
We advise them all the time. That's probably the biggest risk as you age. Because people oftentimes they don't die suddenly anymore because of the medical technology that we
Right.
have.
Right.
And so as a result, their health declines and they reach a point where they can't entirely be independent. And the only thing that's going to cover that is either long-term care insurance or the things that you're talking about, Melissa.
So Medicare, most people get confused about. So Medicare is when the government at, the age that you can get Medicare will pay for your insurance. And so after Medicare, most people get, as you know, like a gap coverage or something, a supplement, Blue Cross Blue Shield, Tufts, or whatever it is. Medicare, if you are what's called a rehabable, will cover up to the first 100 days in a nursing home. 0 to 20 days they pay in full, and then from 20 to 100 there's certain deductibles. But most of the time when my clients go into a nursing home, they really never get the full 100 days, right, because it is based on whether or not they can get rehab. Exactly. And once the nursing home facility feels that rehab is not possible, they give you 3 days notice and you're cut off of Medicare, at which time you either have 3 choices. You have your long-term care insurance pay for the people that have that, you private pay out of your pocket, or you apply for Medicaid. Again, there are certain asset rules based on that Medicaid, but our idea is to try to utilize the rules that are in place legally, to get the client on Medicaid so that they don't have to, spend down all of their assets to be broke.
Okay, here's a good one now, especially today's world. We've seen a lot of it in Sharon. People take reverse mortgages, which is, I don't know, at this point, I'm not even sure. Sometimes I think it's good, other times I think it's terrible, because what's been happening with the reverse mortgages is it gets assigned from this bank to this bank to that bank to this bank, and it always seems to end up with this one company. And the last person dies, and they sit on it. And they sit on it, and they sit on it. Well, no, you can't do it, you can't do that. And they sit on it. The average seems to be they sit on it for 2 years. Now, what if a person doesn't die, he's in the reverse mortgage situation, and his wife dies, he dies, or he dies, the wife doesn't die, because they're in the nursing home, and they have to spend down their assets. But on the reverse mortgage, they stop paying the reverse mortgage because they haven't lived in the house for a year. Or, I mean, those are other rules. What do they do then?
The way reverse mortgage is, and again, it's not for everybody. It is only for certain people. A lot of times you might have a client who owns a house that is the largest part of their estate, and they're retired and they don't have enough income to live or pay their bills. They want to stay in their house. They don't want to sell their house. And so they might take out a reverse mortgage, and that's where the company gives you money up front, but you don't have to pay it back monthly like a traditional mortgage. In our traditional mortgages, we take out money and we owe a principal and interest payment every month. Reverse mortgages don't work like that. They give you the money up front, to live on, and it just builds up interest. So there's advantages and disadvantages. The disadvantage is a reverse mortgage is very costly for people up front. It could be, $10,000 to $15,000 in just the cost to do the reverse mortgage. But it's good for those people that can't afford to live at their house. They get a lump sum of money, and then they can utilize that to live off of.
Okay, so wait 1 second. So now these people, they can't live at the house anymore because they're in a rehab or whatever they're in, and they're never going back to that house, and there's the reverse mortgage on it. So what happens then?
So usually one of the criteria of the reverse mortgage is somebody has to live in the property, or they could force the sale. But you have to remember that even if the house is sold, a lot of times you've already taken the money out. So the house might be worth $300,000, and you may have taken out $250,000 for your reverse mortgage that's already built up a lot of interest. There probably will be close to no value to a house that somebody has done a reverse mortgage on.
Yeah, that's fascinating. You know what? Another thing's going around is they have these ads all the time. Do you have life insurance? If you have it over 100,000, we buy life insurance. Now, I remember a few years ago, they used to go around and do that, and it was like you couldn't do that because actually you're buying life insurance, somebody else's life insurance. The only way you're going to collect is if they die. I'm thinking, what a good incentive. Sell me your life insurance. Tomorrow, somehow or other, you're going to be shot. I mean, how do they allow that?
Well, so I think one of the things you have to remember is if you go into a nursing home and you apply for Medicaid, on the application, it does ask you if you have any life insurance. And what they're really looking for is whether or not that life insurance has cash value. You can have, let's say, $100,000 death benefit. And if it's a certain type of policy called a term policy, there's no cash value. But if you have a $100,000 life insurance policy that has a $10,000 cash value, the nursing home or Medicaid would expect you to spend that $10,000 down before you could obviously get Medicaid. They consider that an asset. Sometimes what people can do, like you said, is they can sell their policy out for the cash value, or for the term that's left, or the beneficiary benefit. I don't have a lot of clients that do that. I'm sure there are, definitely a lot of criteria that needs to be met in order to sell that policy. If I had a client that was going into a nursing home, though, I definitely wouldn't recommend selling the policy because that's just going to bring more value to their estate. They're going to get money. So, a lot of times you don't necessarily want more money because you're trying to spend that down legally.
Well, say you spend down your money, you have nothing now.
Yeah.
You're either in a rehab or nursing home, and there's nobody to claim you. What do they do with these people?
So a lot of times the nursing home will either fill out the Medicaid application for the person, or B, and B, possibly both. They'll go to the probate court and try to be appointed that person's guardian to make healthcare decisions, and conservator to make their financial decisions. So the nursing home might have somebody that gets appointed as that person's conservator, and then they would be able to get bank records and things like that in order to fill out the Medicaid application for them.
Fascinating. I'm thinking of where they go physically. By the way, we only got a few minutes left, believe it or not. I told you to go by fast.
Yes.
One question.
I wanted to ask about if we can get back to the irrevocable trust.
Yeah.
Oh, okay.
Can you talk, excuse me, can you talk a little bit about the pros and cons of one of those trusts?
Definitely. So the pros of doing an irrevocable trust is that it avoids probate, and after 5 years, whatever assets are in the trust will have nursing home protection. However, there are a bunch of disadvantages. The first is that you're not going to be in control of the asset. Let's assume we put your house in there, which is what most people do. as the client, you're really not going to notice much of a difference. You still have to pay the bills, you still have to shovel, you still do everything. It's just that the title on the real estate taxes will come in the name of the trust. The disadvantage, I think, to the trust that some people might have a problem with is, let's assume you have a $100,000 CD and you want to title that in the name of the trust because you want to protect it from a nursing home. And let's assume that CD makes a 2% interest rate, okay? So 2% at $100,000 is $2,000 of interest that CD pays every year. The client can take that $2,000. They can get the income from the trust. However, they cannot touch the principal. They can't touch the $100,000 because if they went into a nursing home and had access to the principal, then it's not really protected. So oftentimes I tell my clients, you don't want to put everything you own into an irrevocable trust. Most of the time people will put their house. The other thing too that people have to remember is you cannot put your retirement accounts into the trust. 401k, IRA, tax deferred annuity, anything that's retirement has to stay in the person's name individually. So I have a client that has a house that's worth $700,000 and we can try to protect that. But if they have $600,000, whatever it may be in a retirement account, I cannot protect that by using an irrevocable trust. So,
and the other disadvantage is banks will not refinance or issue
yes,
a mortgage to a trust.
Good point, right? And so sometimes I have clients that call me later on, years later, and they want to do a mortgage, and I had advised them that no, once you put it in an irrevocable trust, you cannot take out a mortgage. So that's one of the things we take into consideration when we're talking to a client is we say, are you going to need to mortgage this property? Do you need this property to live off of, like a reverse mortgage, or if you sell it, do you need the money? One of the things that people do need to remember is you can sell the real estate that's in the trust. So let's say you have a house for $500,000, you put it in an irrevocable trust and you want to downsize. You can certainly do that. You can replace the $500,000 house with a $300,000 house in the name of the trust. The extra $200,000 has to be titled in the name of the trust in an investment that can be a CD or mutual funds, but you can only get the interest from it. So we go through a lot of paths when we're doing an irrevocable trust. There are a lot of questions I ask, to lead me down the path. One of them being, do you have a good relationship with your children? Are there any problems I need to know about? Because if there are, we don't want to name them as, the trustee of the trust.
Melissa,
Yes.
you are
This
fabulous.
is a timeout. We're going to have to stop.
Yeah, we're going to have to stop. We really want you to come back. I've got other things. You are so good.
Thank
You're so fluent. You're lovely. We thank you for coming, but they're going to cut us off.
All
That's
right.
okay. We can have an estate planning part 2 at some point.
Yes,
Yes,
let's
we
do it.
definitely
All
will.
right. Thank you so
Anytime.
much. You
Thank
really
you
shed
so
a lot
much
of
for
light
having me. I
on
appreciate
the
it.
topic. You shed an
You're
awful lot of light.
wonderful.
Thank you
Thank
so
you.
much. Thank you for being here, Melissa.
Thank you
And
so
to our
much for
viewers,
having me.
thank you for watching, and please let us hear from you if you have more questions or you have other thoughts about topics we could cover on the show, because this is your show, the law, your money, and you.